Supreme Court says First Amendment doesn't protect dog toy. The U.S. Supreme Court has ruled that the First Amendment doesn't protect a chew toy for dogs designed to look like a bottle of Jack Daniel's whiskey. Respondent VIP Products makes a squeaky, chewable dog toy designed to look like a bottle of Jack Daniel's whiskey. The jokes did not impress petitioner Jack Daniel's Properties. It owns trademarks in the distinctive Jack Daniel's bottle and in many of the words and graphics on the label. A tag on the toy states that it's not affiliated with Jack Daniel Distillery. The Court of Appeals for the Ninth Circuit had found that the First Amendment compels a stringent threshold test when an infringement suit challenges a so-called expressive work. Here, so said the court, the Bad Spaniels toy. Also, the Court of Appeals noted that trademark law provides that the non-commercial use of a mark cannot count as dilution and found that the toy fell within that exemption because the toy parodied Jack Daniels. Lawyers for VIP argued that they were following in the playful parodic tradition that has ranged over a half-century from Topps' Wacky Packages trading cards through Weird Al Yankovic. Under the test in the case of Rogers vs. Grimaldi, a trademark infringement claim must be unless the complainant can show one of two things: that the challenged use of a mark has no artistic relevance to the underlying work, or that it explicitly misleads as to the source or the content of the work. VIP argued that Jack Daniels couldn't make either showing and that the toy qualified as a parody and thus, fair use, under trademark law. The Supreme Court disagreed with the Ninth Circuit, finding that there is no special First Amendment protection when the accused infringer has used a trademark to designate the source of its own goods. In other words, has used a trademark as a trademark. Justice Kagan noted that, a bottle of Jack Daniel's, Jack Daniel's Old No. 7 Tennessee Sour Mash Whiskey, boasts a fair number of trademarks. She said that the Bad Spaniels toy was designed to evoke that bottle, with similar coloring and fonts. The court found that use of a mark does not count as non-commercial just because it parodies, or otherwise comments on, another's products. The Supreme Court sent the case back to the lower court for consideration of whether VIP's use is likely to cause consumer confusion between the whiskey brand and the dog toy brand. Someone copied your trademark? Visit us at www.eonlaw.com. Eon Law. Unleashing Genius.